Hello, welcome to our channel. Today in this video I am going to talk about Article 20. What is Article 20? This is protection in respect of conviction for offences. నేరస్తులకి కల్పించే రక్షణలు శిక్ష వేసేటప్పుడు. This is actually fundamental right and it is part 3. This has the 3 clauses. Article 20 has 3 clauses. What exactly Article 20? A person shall not be convicted of any offence under the law which is not enforced at the time of the act was committed. Or in other words, the person shall be prosecuted and punished under the law which was enforced at the time of the act was committed, or the penalty can be imposed by the law which was enforced at the time of the act was committed. ఎవరైనా సరే నేరం చేసినప్పుడు టైంలో ఏ యాక్ట్ అయితే ఏ చట్టం అయితే ఉందో ఆ చట్ట ప్రకారమే శిక్షింపడానికి అర్హుడు, ఒకవేళ ఆ తప్పు అనేది శిక్షార్హం అయితే. సెకండ్ క్లాజ్ ఈస్ double jeopardy. No person shall be prosecuted and punished for the same offence more than once. ఎవరిని ఒకే నేరం కింద ఒకటి మీద మల్టిపుల్ టైమ్స్ కెనాట్ బి పనిష్డ్. ఒక నేరం కింద ఒక మనిషిని ఒకసారి శిక్షింపబడాలి. దట్స్ ఆర్టికల్ ప్రొటెక్ట్స్. థర్డ్ వన్ ఈజ్ self-incrimination. No person shall be compelled to be a witness against themselves. The person being is here accused of any offence. So this article will not protect any witnesses, only protects accused person. ఏ నేరస్తుడైనా తనకు మీద తనే సాక్ష్యం చెప్తే అది చెల్లదు. ఇది 3 clauses as part of the Article 20. So double jeopardy. Double jeopardy means no person shall be prosecuted and punished more than once for the same offence. The condition is here which we need to note it down. Prosecution and punished both need to be met. For the second time trial is barred or not barred, based on this condition is allowed. So for example, there is a case and the prosecution is ongoing and the punishment is not given. So the second trial is allowed. In this case, the prosecution only happened, punishment is not done. So the second trial is not barred. That means it's not violating Article 20 second clause. So there are multiple conditions or scenarios which coming under double jeopardy. First one is if the offences are in the same law and same fact, that means a double jeopardy. That means one act, a filed case in multiple of police stations. For example, they have logged the case in the police station A and they try to log the case in the police station B. That means it is violating Article 20 second clause. The same way, sometimes in the second scenario, one act leads multiple of offences, distinct of offences, different ingredients of offences. So in the same transaction, so one act leads different offences. That offences are also distinct offences. So a man causes a car crash. So in that crash, one person dies, another person has severely injured. So the separate charges possible under different sections. So in this case, single transaction, one act leads different distinct offences. So it's allowed. The third one is administrative action or order is not considered as a criminal trial or the prosecution in the court of law. So for example, if a person was not prosecuted in the court of law, then subsequent prosecution does not attract article. So in this case, there is a customs seized some ornaments, so that is an administrative action. Then later, there was a trial started in the court of the law. So this is not violating Article 20, second clause. So the first one is administrative action. Second one is the prosecution in the criminal law or courts in the court of law. So it is not violating Article 20. Then the fourth one, departmental inquiry is not equal to prosecution in the court of law or in the criminal law. So in this case, there is a case, a government employee is suspended for the corruption. So there is a departmental inquiry has been raised. Then later CBI files the criminal charges under Prevention of Corruption Act. This means it's not violating the 20 article, second clause. So the first one is a departmental inquiry, that's not considered as a criminal trial. The second one is prosecution in court of law. So both are different. In this case, the Article 20 and second clause is not violated. So the key points here is this offence tried again after acquittal or conviction. Acquittal after trial means the person found to be not guilty after the completion of the trial. In that case also, the second time is barred generally. So in some exception cases might be allowed by courts. Different offences from the same act, so that it's allowed. That means one act, it leads to the different distinct offences is allowed. Third one is departmental action plus criminal law. So we have seen it in the customs case. So there is a customs department sees the ornament. There is an action that's not considered a trial or prosecution, and then later there is a trial started. So it is not violating Article 20. So it is allowed. It's not a double jeopardy. Two FIRs for the same offence of the conviction. So it is considered as a double jeopardy, and the second trial is barred. Acquittal in one state, same case tried in another state. This is also considered as a double jeopardy, and it is violating Article 20. So Article 20, ఒక మనిషిని ఒక నేరం కింద ఒకసారి శిక్షింపబడాలి అనేది ఈ ఆర్టికల్ 20 ప్రొటెక్ట్ చేస్తుంది. సో ఒక తప్పు వల్ల రెండు అఫెన్సెస్ జరిగితే, రెండు లాస్ వైలేట్ అయితే, సో 2 సార్లు ట్రయల్స్ అలౌడ్. అలానే ఈ కస్టమ్స్ వల్ల ఏదైనా అడ్మినిస్ట్రేటివ్ యాక్షన్ తీసుకుంటే అది క్రిమినల్ లా ప్రకారం కన్సిడర్ చేయరు. సో ద ట్రయల్ ఈజ్ అలౌడ్. అలాగనే 2 FIRs ఫర్ ద సేమ్ అఫెన్స్ ఆఫ్టర్ ద కన్విక్షన్. ఒకతనికి ప్రాసిక్యూషన్ జరిగి దాని తర్వాత పనిష్మెంట్ అయిన తర్వాత మళ్ళా సేమ్ అఫెన్స్, అదే నేరం మీద ఇంకొకసారి ట్రయల్ రన్ చేయడం అనేది violating the Article 20. That's considered as a double jeopardy. Let's discuss about some landmark cases under double jeopardy. So first one is same offence tried again, it's a prohibited. The case is Venkatraman versus Union of India. It's happened in 1954. The facts of the case: a government officer was subjected to a departmental inquiry and the later prosecuted criminally. So this is what we see before, the condition. The departmental inquiry is not a trial in the criminal law or in the court of law. So in this case it is allowed. It's allowed. Let's see what's judgment. Article 20(02) applies only if the first proceeding is a prosecution and results in the punishment. In this case, the first one is departmental inquiry. So there is no prosecution and there is no punishment. So the criminal prosecution is allowed. So it is not violating Article 20 in this case. So the same offence tried again, so prohibited. Same offence in the two FIRs. So it is the case T.T. Antony versus the state of Kerala, 2001. Multiple FIRs were registered for the same incident of police firing. Once investigation is complete and charge sheet is filed, no second FIR is allowed for the same incident. So prosecution for the same offence more than once violates the rule of double jeopardy. So the thing what we see in the first condition, one act. So the offence is the offences are in the same law and the same fact is attract the double jeopardy. So this is the principle attracted here. So it is prohibited. It is violating Article 20. So it is prohibited. The second trial is not allowed in this case. Third one, administration action is not equal to prosecution. For that principle, we are seeing that third landmark case. Case is Maqbul Hussain versus State of Bombay. A person's gold was confiscated by customs and he was later prosecuted under the criminal law. The first action is customs team confiscated his gold. So that is not a prosecution in the court of law. So the second trial, which is prosecuted in the criminal law, is allowed. So it is not violating Article 20. So one act, multiple distinct offences. That's a permissible, which we seen in previously. So the case is State of Bombay versus SL Apte. Facts of the case is accused was prosecuted for the misappropriation and later for the cheating based on the same act. So here one act, it leads to the two distinct offences. So it is allowed. So it is not prohibiting or it is not violating Article 20. So the last case one is single transaction different offences. The case is Leo Roy Frey and versus Superintendent District Jail. Facts: foreign national prosecuted for fraud under the customs and the later for passport violation. So here you see that different offences. One is fraud, foreign national prosecuted for the fraud under the customs. Second one is passport violation. So both are different offences, but the single transaction, that's a foreigner coming to the India. So the judgment is different offences with the different legal ingredients, no violation of double jeopardy. So this is not violating Article 20. So the scenarios are here is the key scenarios. Departmental plus criminal law is allowed. Second FIR for the same offence is not allowed. Administrative penalty plus criminal law is allowed because both are different activities. Fourth one is different offences for the same act. It's allowed. Same offence, two trials is not allowed. Two trials is not allowed. It's directly violating the double jeopardy principle. Civil plus criminal cases on the same facts is allowed. So this Article 20 protects criminal laws. So civil proceedings plus criminal cases on the same facts is allowed. So it is not considered double jeopardy. The next one is self-incrimination. The principle is no person shall be compelled to be witnessed against themselves. The person should be accused of any offence, not the witness. ఏ నేరస్తుడైనా తన మీద తనకు సాక్ష్యం చెప్పే అధికారం లేదు. దట్స్ నాట్ కన్సిడర్డ్ an ఎవిడెన్స్. So in this case there is a physical evidence and testimony. There are two concepts are there under self-incrimination. So testimony is it's like a witness. The person has given a statement in the judicial proceedings, the statement is considered as a witness for the case. Physical evidence is something like giving a blood samples or signatures or fingerprints, handwriting samples, voice samples or DNA tests. All these are considered as physical evidence. So it is not violating Article 20, third clause, that compelling to be witnessed against themselves. So the only concern is protect is written statement admitting that involvement, verbal answer during the custodial interrogation, all this prohibited. So no one can compel any accused person to be a witness against himself. So this is the self-incrimination. There is a landmark case under the self-incrimination. That's the State of Bombay versus Karthik Kalu. It's a creation in 1961 and bench is 11 judges. Date of the judgment is December 7, 1961. The legal question of this case is, does compelling an accused to give a fingerprints, handwriting or signatures violate Article 20, third clause of the Constitution, which protects against self-incrimination? ఎవరినైనా వాళ్ళ ఫింగర్ ప్రింట్స్ కానీ, లేకపోతే వాళ్ళ హ్యాండ్ రైటింగ్ శాంపుల్స్ కానీ, వాళ్ళ వాయిస్ శాంపుల్స్ కానీ, వాళ్ళ బ్లడ్ శాంపుల్స్ కానీ ఇస్తే అది 23 వైలేట్ అవుతుందా అనేది లీగల్ క్వశ్చన్. ఇక్కడ జడ్జిమెంట్ వచ్చేసరికి వైలేట్ అవ్వదు, ఎందుకంటే ఇది ఈస్ కన్సిడర్స్ అ ఫిజికల్ ఎవిడెన్స్. It is not compelling the accused person to be a witness against himself. సో అందువల్ల ద జడ్జిమెంట్ ఏమొచ్చిందంటే ఇది 20 ఆర్టికల్ థర్డ్ క్లాస్ వైలేట్ అవ్వట్లేదు. సో ఇది పోలీస్ వాళ్ళు కానీ ఈ ఇన్వెస్టిగేషన్ టీమ్ ఐడెంటిఫై చేయడానికి కోసం తీసుకునే శాంపుల్స్ అతను మనం కంపెల్ చేయట్లేదు, నువ్వు తప్పు ఒప్పుకోమనేసి. అందువల్ల ఇది ఆర్టికల్ 20 థర్డ్ క్లాస్ అనేది వైలేట్ అవ్వట్లేదని జడ్జిమెంట్ ఇచ్చారు ఫైనల్ గా. దట్ ఈస్ ఫేవర్ టు ద స్టేట్ ఆఫ్ బాంబే. స్టేట్ ఆఫ్ బాంబే ఇస్ రెస్పాండెంట్, accused person is petitioner. So this is the self-incrimination. So in the summary, what exactly Article 20 is doing is protection in respect of conviction for offences. The main theory is it is not a retrospective in criminal law. So a person shall be prosecuted and punished under the law which was enforced in at the time of the act was committed. ఆ తప్పు చేసిన టైంలో ఏదైతే లా చట్టము అమల్లో ఉందే ఆ చట్ట ప్రకారమే శిక్షింపబడాలి. అంతేగాని ఇప్పుడు ఒక కొత్త చట్టం ఉంది ఆ చట్టం ప్రకారం శిక్షింపడానికి కుదరదు. రెండోది వచ్చేసరికి doublejeopardy. A person cannot be prosecuted and punished for the same offense more than once. ఏ నేరస్తునైనా ఒక్కసారి శిక్షింపబడాలి ఆ ఒక్క నేరానికి. మూడోది వచ్చేసరికి సెల్ఫ్ ఇంక్రిమినేషన్. థర్డ్ వన్ ఇస్ సెల్ఫ్ ఇంక్రిమినేషన్. ఏ పర్సన్ shall not be compelled to be a witness against himself. That person is accused of any offense. ఏదైనా నేరస్తుడిగా ఉన్న అతన్ని భయపెట్టి కానీ ఇంకే విధాలుగా చేసి కానీ అతను నేరం ఒప్పుకొని అతనే ఆ నేరానికి సాక్షిగా ఉండేటట్లు చేస్తే అది వైలేట్స్ ద ఆర్టికల్ 23 ఆర్టికల్ 20 థర్డ్ క్లాస్. సో ద ఆర్టికల్ ప్రొటెక్ట్స్ ఫ్రమ్ దోస్ యాక్ట్స్. ఈ సెల్ఫ్ ఇంక్రిమినేషన్ లో ఈ ఫిజికల్ ఎవిడెన్స్, బ్లడ్ శాంపుల్స్ కానీ, వాయిస్ శాంపుల్స్ కానీ, హ్యాండ్ రైటింగ్ శాంపుల్స్ కానీ ఇవేమైనా ఇచ్చేవి అది ఇస్తే అది సెల్ఫ్ ఇంక్రిమినేషన్ వైలేట్ అవుతున్నట్టు కాదు. అది యాజ్ పార్ట్ ఆఫ్ ది ఇన్వెస్టిగేషన్. అలానే ఆ నేరస్తుల దగ్గర నుంచి భయపెట్టి ఏదైనా రిటర్న్ స్టేట్మెంట్ కానీ, వెర్బల్ స్టేట్మెంట్ కానీ, నేనే ఆ నేరాన్ని చేశాను ఒప్పుకోమని చెప్పడం కానీ ఇలాంటివి చేస్తే then it is violates the self-incrimination. So a person shall not be witnessed against himself.